The 2015 amendment to the Labour Relations Act has sparked much debate, especially the changes as they relate to the temporary employment services. Before the Labour Appeal Court judgment, there was a unique triangular relationship between temporary employment services and employee rendering services and the client of the TES. Joining us is CDH Director Professor Hugo Pienaar, who will unpack this issue for us. Professor, before the ruling was made, how was South Africa's relationship in terms of labour brokers?
Well, it started off in 2015, as your introduction said, and that introduced a new deeming provision. It said after 3 months, employees below the threshold will be deemed to be the employees of the client. And that's where that originated the triangular relationship. Of course, alternatively known as the dual employer test. And the opposing to that, you had the unions or other views that said there must be a sole employer test. Their view was that after 3 months, for those employees below the threshold will be transferred to the client. So the labour broker would fall out of the picture and there would be no more labour brokers, effectively a ban after 3 months. So that was the position, or the position of the different parties. The Labour Court supported in the Brassey AJ judgment the triangular relationship, and the TES, or the labour broker, remained on the scene as the employer of the employees, whilst the client still became the deemed employer. Of course, what happened in the assigned judgment when it went to the Labour Appeal Court, the Labour Appeal Court now supports the sole employer test. So effectively taking the labour broker or the temporary employer services out of the picture and saying those employees now become the employees of the client, and the client becomes a statutory employer. And so effectively saying that's now the sole employer test. In fact, says so in that judgment.
And just tell us more about this judgment. What does it mean for employees, and what does it mean now for companies that hire employees?
Yes. Well, first of all, that judgment will be going to the Constitutional Court, which effectively means this judgment it will now be stayed pending the outcome of the Concord's decision. So for the moment, the Brassey judgment will stand, i.e. the triangular relationship, or the labour broker will remain on the scene. So that's for the moment the position. Of course, what companies and labour brokers typically do now is to say, well, are there alternative models? Should we consider alternative models, etc.? Because what was predicted in 2010 already in the regulatory impact study was that this new type of legislation will potentially create more unemployment, and it will cost more. And if you look at the latest statistics, that's exactly what has happened. It was envisaged that the employees of the labour broker would simply be transferred to the client. But that has not happened. Only 20% of those employees were effectively transferred and 50% terminated. Now there could be other causes for the termination too, but those are high figures in a country where we have a high rate of unemployment.
And there is a model that could help all the parties meet at a level ground, the management service provider model. Can you tell us more about that model and how this will help employees keep their jobs and employers keep employing people?
Yeah, well, because that's what you ideally want, isn't it? Because we live in an environment where locally and internationally, where's the highest growth in creation of employment is in the atypical sector. At the same time, you don't want to exploit labour. You want to protect the enshrined rights in terms of the Constitution. Yeah. So what you now want to create is a different sort of model, a sustainable model. And what we did in our firm is with AdCorp, the AdFusion company, to create a new sort of MSP model with the client. And that was introduced at Shoprite Checkers, and there's a reported an award on that where the court has now, or the arbitrator has accepted that concept. So what it really does, and I have to show a bit, is that historically you had the client, you had the labour broker and the employees. And what it simply meant is that because of the deeming provision, those employees now, because of the assigned Labour Appeal Court judgment, become the employees of the client. What the MSP model does, it introduces a new management service provider, an expert service provider. So you will now have in the Checkers concept, Shoprite Checkers concept, and it's a reported case, so I'm not sharing confidential information, is that you now had Shoprite Checkers historically here with the labour broker and the employees. You now have Shoprite Checkers. You now have a management service provider, the expert service provider. That expert service provider appoints various subcontractors, about 105 others, and let's say in this case about 6 labour broker employees. And then you have the employees below that. So the MSP, provided it's a genuine subcontractual relationship, becomes the deemed employer. And that takes Shoprite out of the picture, and there's no dispute about joint and several liability, there's no dispute about equal pay or equal treatment and all of that. And what the case has shown is that the productivity has increased at that particular warehouse, it's reported in the ruling, from quite a low figure to more than 70%.
All right then. Thank you very much. That was Director SCDH Professor Hugo Pienaar breaking down the Labour Relations Act.